Robson Radio is the official podcast of the University of Manitoba's Faculty of Law. This podcast is recorded on the original lands of the Anishinaabeg, Ininawuk, Anishinaabe, Dakota, Oyate, and on the national homeland of the Red River Métis. This podcast comes to you from the MLT Aikens classroom at Robson Hall and was created using equipment kindly sponsored by MLT Aikens. The goal of Robson Radio is to tell the story of Western Canada's oldest law school in Manitoba. Each episode features an interview with one of our professors, directors, staff, students, or alumni, or special guests, all of whom make our law school an exciting, relevant, innovative, and transformational place to be.
Hello, everyone, and welcome to this episode of the Robson Hall Criminal Law Podcast. I'm your host, Tesia. Today, I'm very pleased to be joined by Wendy Martin White, a criminal defense lawyer practicing in Manitoba with over 30 years of experience. So today, we're really going to focus on bail, how recent proposed legislative amendments will affect our bail laws, and also how it may impact marginalized individuals, specifically those individuals who struggle with their mental health or with addictions or with housing insecurity. So a lot of times, public perception is shaped by a small number of high-profile cases that make their way into mainstream media, but those cases don't necessarily reflect the everyday realities of bail and of the individuals that are involved in the system. So before we get into the legal framework, it's important to ask whether public reaction and political pressure always reflects how the system actually functions, or whether something more nuanced is missed.
It's easy to get the public riled up when it comes to these things, but it's not necessarily an indicator that the system is broken. It's easy to say it's broken, but it's not necessarily broken.
So before jumping into the discussion, I think it's important that we clarify what we mean when we say bail or release. A large part of this conversation depends on understanding those terms, and it's important to understand that bail is not a one-size-fits-all. Whether someone is released depends on a variety of factors, but every decision is highly case-specific and ultimately up to the judge or judicial justice of the peace to determine. So there are different pathways to release from custody. In some cases, police can release someone directly from custody after they've arrested and charged someone by way of an appearance notice or an undertaking. Other cases may require a bail hearing or a form of judicial interim release, which is our Canadian legal term for bail. So a bail hearing would take place before a judge or a judicial justice of the peace in Manitoba. Sometimes the Crown and defense agree on a release plan, and in that case, it would be considered a consent release where the conditions have previously been discussed in advance, and they put a joint proposal before the court where if the judge is satisfied that the conditions are appropriate, the individual is typically released. We also see contested bails, and so this can happen because maybe the Crown and defense can't agree on conditions, or perhaps the Crown is opposed to release altogether. Bail conditions must be reasonable and justified and consistent with the Charter of Rights and Freedoms and previous case law. In practice, for minor or first-time offenses, conditions may be very basic. You may see conditions like requiring that the accused attend court for any appearances, or that they should reside at a specific address. But for more serious cases, or for individuals with a longer criminal record of convictions, the conditions can be much more restrictive. So some examples of some more onerous conditions include curfews, for example, 11 p.m. to 7 a.m., or an accused may also be subject to an absolute curfew. So that's where they would be required to be at their residence 24/7, with limited exceptions usually relating to a medical emergency or if they have a court appearance. You might also see a GPS ankle monitoring condition, and those are often imposed when there are concerns about court attendance or if the accused would be considered a quote-unquote flight risk. Oftentimes, it seems that bail is misunderstood or oversimplified in public discourse when it is a much more complex portion of the criminal justice system. And so this is where real-world experience is essential. Wendy sees how the justice system operates day to day, not just in theory. And she also has experience with clients who have a wide range of needs and circumstances. And so, bearing that in mind, Wendy, can you discuss the 3 statutory grounds for bail?
The state cannot deprive you of your liberty, your freedom to go about your business, unless there's reasonable basis for doing that. And so as a result of that, we know that there are a number of grounds that the courts look at when they consider whether somebody is bailable or not. And we tend to look at the primary ground, which is whether or not they can be trusted to come to court and to comply with the conditions of a court and to not interfere with the administration of justice. The secondary grounds, which is that the court have confidence that there's not going to be a reoffending or substantial reoffending, a substantial likelihood of reoffending. And then thirdly, a tertiary ground, which often looks at sort of the type of sentence they might be looking at down the road, the strength of the Crown's case, and whether or not there would be a loss of confidence by the public. And that's not sort of an unreasonable public, but one that's well informed about the bail system and the rights of individuals to be presumed innocent until proven guilty.
So, how do you explain that presumption of innocence to your clients when they've been denied bail and are being detained in custody while they await their trial or disposition?
Well, that presumption is always there, but the courts, don't always consider the fact that they're awaiting a trial. They look at their history, which typically is if they have a criminal record. They look at if they keep coming back into custody on breaches or substantive new offenses. And those sometimes end up being the sort of death knell, if you want to call it that the courts say you're going to get your day in court, but you're going to be in custody while you await it because either you can't satisfy me any longer that you're going to comply with conditions, or you're going to, if I release you, not commit new offenses. So they try to give meaning and reasonable meaning to what that means, which is generally you should be released awaiting trial. But if your track record is such that, you're not complying with conditions or you can't come up with a plan where you're going to address maybe perhaps addictions issues or things like that in a meaningful way that will address either breaches or reoffending behavior, then the only options left to a court sometimes is to just keep the person in custody while they wait for trial.
So, bearing in mind that despite the presumption of innocence, detention is still a possibility when someone is charged and therefore a potential outcome of a bail hearing. Can you walk us through the practical realities of a bail hearing?
So I would say it's the perennial question or answer to a question you get, which is it depends. But it really does depend on what the charges are and where the person is located and what kind of plan they can come up with. So sometimes, for example, if there's a situation where there's been offending behavior against a particular person, you might be able to craft a plan where the person no longer lives in the same community or lives in the same vicinity or city as that person. And that will be enough for a court to say, okay, that satisfies me that we've done what we can to put some boundaries of protection around the complainants or other witnesses, for example. So sometimes that's the easy answer. Sometimes it's, if the person has addictions issues, we get them into a treatment program, and that's enough to satisfy the usually primary and secondary ground concerns for a judge. Sometimes it's just having someone that the court can depend on in the community to watch the person. And so we call those persons sureties. They can be named, which means that they're simply not putting up a financial or qualifying financially. There's still a monetary amount that's usually associated, but they will sort of say, I'm going to be the jailer in the community, or I'm going to be watching them in the community. And if they don't follow the conditions or they don't get to court, then I'll report them or I'll revoke my surety. So sometimes it just depends on what the record is and what you can anticipate that the Crown is going to raise or that the concerns the court might have. And you try to fit a plan that will best address those needs. And so in the practical sense, you're really trying to work through with the client, what resources do they themselves have, or what can we draw upon in the community so that we can actually get them bail.
One thing that I'm really struggling with what you were discussing is the issue with the courts imposing a condition that would require your client to abstain from using a substance if your client is actively struggling with addiction with that substance. And how do you balance that with your client's right to exercise bail while also ensuring that you set them up best to not fail to comply with their conditions?
Yeah, I mean, I what I always find interesting is that when they're presumed innocent, the courts will impose those kinds of restrictions on them more so than if they pled guilty to an offense and those were substantive issues that the court wouldn't want to set them up for breaching. So it's kind of this funny paradox, but I think the court's sort of rationale is, I want to be able to trust this person in the community, and I don't think I can trust them in the community if they are not going to promise to abstain. Some judges will be more, I think, reflective on the nature of the breaches or the substantive offending, and they may just say, I'll release you. I don't want you to be intoxicated in a public place. So in other words, you can, if you have a significant addictions issue and you're going to stay in your home and not go out, I'm not going to impose that kind of a condition. But more so if it's a serious offense, you're going to see an abstain clause. So it's problematic because they may want to abstain. They may honestly believe that they can abstain, but there's no question that we see clients coming in on a regular basis with breaches of their abstain conditions. And it's usually because they are addicted and it's a difficult condition to comply with.
It's disappointing and unfortunate that in some cases, an abstinence condition might be the only condition with which the Crown or the court would agree to release when it's very clear that a lot of individuals involved in the system are struggling with addiction, and imposing a condition such as that alone without meaningful treatment and meaningful reform isn't necessarily the best solution. I think that it is a step in the right direction, though, that the courts and that the Manitoba Court of Appeal has recognized that it would be unrealistic in some circumstances to impose an abstain condition when sentencing an individual to a probation order, for example, because it wouldn't be in the best interest of either the individual or the public to set them up to breach from the outset. I suppose, though, there's not necessarily that understanding yet when it comes to bail. And so I imagine that a lot of individuals are remanded into custody either because they were denied bail from the outset or because they have failed to comply with a condition. And so how does being remanded into custody affect your client's ability to understand their options and instruct you and make informed decisions about their defense?
I mean, there's no question that once they're in custody, your client's ability to mount a more meaningful defense is compromised, especially if they don't have people in the community who can access the kinds of things that you might need from their home or their computers or their bank accounts or whatever it is that's going to matter for the defense. If they don't have those kinds of resources, it makes it really difficult to put in that kind of fulsome defense for them. And those are the kinds of independent types of evidence that can make or break the credibility, as I like to call it, the sort of meter that a judge considers, because they'll oftentimes, maybe have second or third thoughts about whether to believe your client. But if you've got some, sort of corroborating documentary evidence or other witnesses or things like that, that can make a difference in your client's case. And so it makes a big difference. And it just also, the environment is not always the best for their mental health. So they're not at their best in terms of performing, if you want to use that word. And I don't like to use that word, but we have to remember that usually trials take place in a day, or at least your client or the witnesses that you might even cross-examine are only there for a day. And whether they're at their best, in terms of sleep and mental health, have they been given their medications, all of those things play into how well they will do on the stand. And I've had to sort of, in consultation with clients, make the decision that, I don't think you are in the best state to testify. I don't think that you'll come across well. And it could be for a number of different reasons. I mean, it's not always just their personality. It can very much be